Hello, my name is Kathleen Heaston. I have been assigned to do the competency to waive counsel and self-representation. There's three groundbreaking cases that helped determine whether a defendant can waive his right to counsel and self-represent himself. The first one was Godinez v. Morin, and the second one was Ferretta v. California, and finally there was Edwards v. Indiana. In Ferretta v. California, Ferretta was charged with grand theft. He filed the motion to discharge his public defender, and it was originally granted. However, after further questioning from the judge, he was appointed a defense attorney due to Ferretta not being competent in his own defense. The United States Supreme Court held that the Sixth Amendment guarantees criminal defendants a right to self-representation. The court emphasized that a defendant is not incompetent to waive the right to an attorney merely because he or she may be unable to understand technical legal matters. In Godinez v. Morin, Morin shot and killed a bartender, a customer, and then his wife. He then tried to kill himself, but was unsuccessful. He tried to slit his wrists instead. Later at the hospital, he confessed to all the murders. He originally pled not guilty with attorneys, but when he was examined by two psychiatrists who stated Morin was fully aware of what he was doing and that he had the ability to assist his attorneys, he then appeared before the court requesting to dismiss his attorneys and represent himself, and to also change his plea to guilty. His request was approved, and he was sentenced to death. The court in this case found that the competence to stand trial and the competence to plead guilty to be equivalent, but also held that a person who is competent to stand trial is competent to waive the right to an attorney. In Edwards v. Indiana, Edwards was charged with attempted murder after stealing a pair of shoes and shooting a security guard and a bystander. He was originally found incompetent to stand trial, but after 5 years of antipsychotic medication, he was restored to competency. He then filed a motion to dismiss his counsel, which was originally approved because he was competent to stand trial, but was later overturned by the judge when Edwards tried to admit into evidence rambling and irrelevant documents. The court held that the defendants who are competent to stand trial and waive counsel may nonetheless be required to accept counsel if they still suffer from serious mental illness to the point where they are not competent to conduct trial proceedings by themselves. In assessing the examinee's understanding, the first part of an assessment is to see if the defendant understands the kinds of tasks an attorney performs. The examiner should not next assess the reasons for wanting to proceed pro se, with seeing if the defendant suffers from any type of mental disorder like defeatist attitudes, paranoid ideation, clearly fantastic objectives, or irrational beliefs. Defendants who want to proceed pro se because they think they can do a better job than a lawyer, who believe that a lawyer will not effectively communicate their message, or who disagree with the lawyer's objectives and strategies are not likely to be found incompetent unless their reasoning is clearly irrational. Competence to represent oneself. Although it is uncertain why individuals in trial dismiss their attorneys in an effort to represent themselves, it is clear that they usually have an adverse effect on the outcome of the trial and leaves the defendant without the aid of a legally trained advocate. In the journal article that I found for this project, it was about competency to waive right to counsel, and it talked about a gentleman named Mr. Kowalski, who was 33 years old, and he was arrested with child pornography, which was allegedly found on a laptop in his possession. In federal district court, he pleaded not guilty, but was assigned to two public defenders. In December 2009, the public defenders filed a motion to withdraw as his attorneys. The motion was granted, and Mr. Kowalski was appointed a new attorney who was a co-attorney moved to withdraw in October 2010. Mr. Kowalski's father hired a psychologist in November 2012 to evaluate him. The psychologist opined that Mr. Kowalski was not competent to stand trial and was unable to work with attorneys due to irrational paranoia. And my discussion question for everybody is compare and contrast the pros and cons of waiving your right to counsel and representing yourself. Thank you so much.